that I want to know about. Now, almost every single one of these issues we'll talk about, we've dealt with in one way or another. Whether it's on a litigation, and we'll maybe tell some war stories about dealing with that, or whether it's a tax issues. Robb, who is actually the former head of the Maryland State Bar Association's tax committee, and actually sits on, has had numerous leadership positions in the American Bar Association's tax committee. He's going to talk about even some tax and transactional risks. One of the benefits of our firm is because we have numerous attorneys. We actually have another partner of ours, Ted Kivian, is here, and actually Glenn Ivey is here. We've actually worked with, he works in Prince George's County's firm. We've worked together with him on a number of issues as well. We believe in collaboration. And one of the benefits that we can bring is because we have so many different attorneys on tax issues, litigation issues, contract issues, that if a business person comes to us with either a dispute or a problem, usually not only can that attorney help them, that expertise, they can get a collaboration from another attorney. So if you have a contract drafting issue that you want advice about, we've got attorneys who've litigated almost any type of contract that's out there, so they can advise not only that contract drafting attorney is, oh, here's a pitfall, one of the pitfalls we're going to talk about here. So we'll kind of start, and let Robb start off with kind of one of our first legal pitfalls.
Yeah, one of the issues we see with a lot of businesses that I can see is the failure to file a personal property tax return. Every business, when you incorporate or organize as an LLC or corporation, and even sole proprietor, required to file an annual tax return for the State Department of Assessment and Taxation on April 15th, the same day your personal tax return, your corporate tax returns are actually due today. Sorry. So one thing is, if you fail to file the personal property tax return, your organization and corporation will no longer be in good standing. If it happens more than once, and usually 2 years after that, you actually have the ability, and the State Department will actually forfeit your company name. What does that mean? It means somebody else can come in, organize, and incorporate and take the name that you have. It also means that all that corporate liability and all the liability for the company and the protection that you had by setting up that company is no longer available to you. So if the company gets sued, it is no longer necessarily the company getting sued, but they can sue you individually. And there is then personal liability for the owners of the corporation or the company. So it's extremely important that every year that return gets filed timely. There is not really much computing done with it. You enter in the value of your assets. It's a $300 filing fee, and then based upon that, the county where you're located will make an assessment on the personal property taxes and will send you that notice. You will only get forfeited if you don't actually file a personal property tax return. You don't actually get forfeited if you don't pay the county their taxes. However, they will eventually come after you separately. So that is still recommended and always required to do.
So it's interesting talking about real world war stories. I cannot tell you the number of times that this issue has come up. People think it's kind of a minor issue because, oh, it's just kind of minor violence. We have been involved in numerous cases where the clients come to us. I need to sue them. We need to get our money back in this contract. Turns out that's bullshit. They can't sue. We have to now go through all the transactional attorneys and tax attorneys to get that back. In addition to which, there's at least been 4 different times that we're brought a case. And it turns out the other side, the company, is actually a forfeited company. Therefore, we can sue them. That company can't sue us back. Even if they have a valid claim, they're barred from it. In addition to which, even if they can't resurrect it, which sometimes they can, I can tell you it doesn't look good before a court when you're being sued, and as part of the proceedings, you have to announce to the court, oh, we weren't forfeited, now we're okay, we can now participate in the legal proceedings.
Yeah. And typically getting reinstated is not that difficult in the sense that you have to file all the missing personal property tax returns, pay all the missing fees, as well as the penalties and interest that's accrued. But sometimes, at least now and during COVID, I mean, if you can't do it online and you have to do it by mail, it can take 8 to 12 weeks just to process everything. So once you get the tax returns processed, then you also have to file a document to be reinstated. So that can be sometimes a 24-week process. So it's not something that you want to lapse on, because when you get into that situation where the court dates arise, those are coming no matter what. And you need to make sure that you are protected and through that entire time.
So another issue that we advise almost all of our business clients is the use of releases. Releases are, as we advise our clients, a critical business tool for preventing your future liability. Now, a lot of people think of releases, oh, if I'm just sued, I'll get a release after the settlement, but they can be used in the regular business context. An example that I give all the time is almost all businesses have employees, not just W-2 employees, but also 1099s. Sometimes you get into disputes with your attorney, your employees, or even your 1099 independent contractors. That happens in almost every business. I've hardly dealt with a business where they've not gotten into some type of dispute. And usually it's resolved internally, where they say, okay, we'll give you that extra pay, or we'll do this to kind of break apart from each other. As part of that negotiation, you can get a release. And we advise all of our clients, or usually advise our clients, when there's a dispute or someone's leaving, as part of that negotiation of how you're going to break apart, get a release. Because if you don't get that release and they're disputing about something, they can later sue you. You can get yourself, as I often refer to it to the business clients, as a get out of jail free card, because you've gotten this release. This can also be applied to businesses. You're disputing with another business, and they're disputing about an amount or something that's owed or might not be owed. If you actually settle that dispute without a release, there could be another aspect of that dispute. They could later sue you. If you don't get that release, you could later still be liable to some aspect of that transaction. So having that release, being able to be drafted, and even just talking, I mean, I can usually sometimes talk to a client for less than an hour and say, oh, a release would be helpful here. Let's work on drafting it. That simple act could potentially save you tens to hundreds of thousands of liability dollars.
And like Adam was saying, the release isn't just the entire contract. You have to look at the entire contract with regards to things such as indemnification. Indemnification really acts in many ways as a general release. So, for example, if you're buying a product, if you're buying a business, you want to ensure that you have indemnification, which is going to be that part that protects you for any liability that maybe another individual has caused. So those are the things that you really want to look for in these contracts. A lot of times when I review contracts for businesses, one of the things I will tell you is that they're coming from the corporate headquarters, and that release and that indemnification is always going to be there to protect them, but it's not usually in there to protect my client. We added it. The thing you should know about a contract is every contract can change in 99.9% of the cases. There is that 0.1% of the time when the person's not going to negotiate with you if you change their contract.
By the way, this is prior to signing.
Prior to signing, yes.
Not to make that clear.
But you want to ensure that you go through that contract and you review it and you make sure that it's going to work for you, that you are protected as much as they are protected underneath that contract. There are times where I've worked with clients and we've gone through months of negotiations on a contract, and it's come down to one or two little sticking points. And my clients have walked away because they aren't going to be fully protected. But the thing is when you start off with that contract, we go through, and a lot of times people will send them to me and as an Adobe, I'll ask, can we have it in Word? Because I'm not going to take the time to read through it in Adobe and have to write everything down. I'm going to go through and I want a red line. And people are sometimes shocked at the amount of red line that comes back. But feel free to red line as much as you want. Ask for what you need. Ask for what's going to be important to you, because you don't want to just go in there and sign whatever they're doing. When you're dealing with credit card companies, you're going to have to sign what they want you to sign. When you're dealing with, things along those lines, usually even sometimes with bank loans, we will modify the documents to put in different restrictions. So it's important to realize you can modify any contract out there. It's important to go through that. There's always business decisions, as I say, and legal decisions. The business decisions, how much am I going to pay them? I'm not going to really have an effect on that. That's not my decision. Where I am going to have an effect is how long the indemnification is for. How long are the non-solicitations for, the non-competes? Those are the types of things that you really want to focus on and try to amend what you're trying to protect, which either side of the market.
So on this is kind of the third topic, contract concerns. I can't tell you the number of times people come to us, either Rob or I, and say, I got myself in this contract, what can I do about it? Just as Rob said, you've got to make sure that before you sign it, you're dealing with the concerns. Two issues that I see all the time with contracts. Number one is an attorney fees provision. I primarily do the litigation on disputes within businesses. And the number one question I'm asked when a business owner or a business operator or business president comes to me is, am I going to be able to recoup the fees that I'm spending on you in negotiating this dispute? Unless you have it in the contract or the law, marital law gives it to you, which is extremely rare, you're not going to be able to recoup. So Rob and I advise almost all of our clients, when you're negotiating a dispute, as long as you believe you're going to fulfill everything in here, put a legal attorney fees provision. And what we often do is we don't just say pay attorney, we say attorney fees to the prevailing party. What does that do? It's if you have to enforce this contract against your other side, or they falsely try to accuse you of breaching, you've got this clause in there that if you win in court, or you win in arbitration, or whatever the dispute resolution medium is, they're going to have to pay your attorney fees. Why is that good for a business? Because the expense of having to deal with lawyers, I always tell clients, you're better off spending as little money on me as possible. If I can get you an attorney fees provision in your contract to later deal with the dispute, you're going to pay less money than attorney fees. Another issue that comes about.
One thing I'll say real quick on attorney's fees also is, as Adam said, that prevailing party is very important. I have seen contracts lately, and even within the last month, where I reviewed them, and what this says is that if you litigate against us, you will pay our legal fees. So whether we win or lose, if you want to fight us, you're going to have to pay for it twice. You're going to pay your own lawyer, you're going to pay our lawyers. And that's where we've gone through and cut that out.
I thankfully have never seen that.
It's really, it's something. And I'll be honest, I have seen contracts and I look at this, I go, who would sign this? This is so one-sided. And those are things. So I remember years ago, somebody once told me, or when I was younger, way before I became an attorney, they said, when you're reading through this document, just look at really the bullet points. And you'll see something there that says attorney's fees. You go, great, it has attorney's fees, wonderful. But you don't know what it says. So you have to read the fine print. You really do have to go through it and see where that language is. And then also defined as to what does a prevailing party mean? Does it mean we go to court and the judge says it? Or does it mean that I eventually pay more in legal fees than you could and you just caved, therefore I prevail? So it's very important to look at the specific language.
So one other issue that I think pertains to business that I'll bring up, even though I think on contract terms I could spend half an hour by itself, is arbitration. Most business textbooks, and even websites talking about what businesses should know, say businesses should always put in their contracts an agreement to arbitrate. Why? Because from start to finish, an arbitration is more efficient and more cost effective than going to court. I, however, advise most of my clients against it. While it is true that in many cases, if the parties are going to be going to full battle, arbitration is more efficient and more cost effective from an attorney's division and a cost perspective. However, there's a number of problems with arbitration. Number one is, if you go to court, your filing fee is generally under $200. That's as little as $100 just to file your lawsuit. In arbitration, to start that process, they want a percentage of whatever in dispute. I've seen arbitration starting fees as much as $10,000. Now, why does that matter? At least within our firm, and almost every stat that I've seen, upwards of at least 90% of all civil disputes are settled before they actually get to trial. Well, why is that important? If you've spent $10,000 already on an issue, do you have an impetus to settle? No, you've already got your investment. You want to go all the way. Well, you've only spent your attorney's fees. And that $100 on the court filing fee, you actually might settle. Arbitration and that instant amount of money you have to pay sometimes precludes a settlement that could be more cost effective for your business. Another issue with arbitration that people don't realize is under the court system, you have rules of evidence and you have rules of procedure that have to be followed. An arbitration, including AAA arbitration, says those are just guides. They're never mandatory. I was actually involved in litigating an arbitration that was required to go to arbitration, where after all the evidence was in, and the parties were actually presenting their closing arguments to the arbitrator said out of the blue, hey, does anybody know if this document existed? It was never part of the evidence, nobody presented, and he made the parties go back, looking through all the documents to get it. Turns out it was negative against our clients. And I had to adjust what I was doing at the end. That never would have happened before. Wouldn't be against the rules of procedure, wouldn't be against the rules of evidence. But it's happened, and I can't tell you how it's happened in arbitration. I'd rather know what my rules are than have an arbitrator who isn't bound and also not appealable. If you have an arbitration that's binding arbitration, you're stuck with that decision. Now, there are ways, if there's a extreme bias by the arbitrator, have the court system revoke it. But if you get a bad decision from a bad judge in court, you can appeal it. You can't always do it with arbitration.
We've talked about contracts, but I want to specifically talk about employee contracts. And some of the things that that we see in employee contracts. One is going to be a non-solicitation. Non-solicitation will go both for other employees. So if my employee leaves, he can't take my other employees and go with him. Number one. Number two, he can't solicit my clients and take my clients with him. You want to protect that investment. So make sure you have a non-solicitation. Non-competes. Now, non-competes are a little bit more difficult. One of the problems is that they have to be reasonable. If you say you can't compete anywhere in the US, at all, and you have a restaurant, it's going to be very hard for that person, especially let's say if they're a waiter, to be able to go and find another job as a waiter anywhere else. So they have to be reasonable. You can't work within any location within 10 miles of this current location for 2 years. That's a little bit more reasonable. We limited the amount of time, we limited the location. So as long as you're looking at something that's reasonable, that's fine. The enforceability of a non-compete is going to be a little bit more complicated. Because you're going to also have to prove damages. You're going to have to show how was your business hurt by this person competing with you, and what business did they take from you. And if they take your clients, that's one thing. If they take somebody who you say would have been your client, it's another completely different thing trying to prove it. It's going to be much harder to prove. When you have employee contracts, you also want to have them be at-will employees. What does that mean? It means you can fire them at any time for any reason whatsoever. I have clients who call me all the time and said, oh, this person's been horrible, they've been slacking, they haven't been doing their job, they come in late every day, I want to fire them, I want to tell them all these reasons. I go, that's fine, but you don't have to. If you start listing off all these reasons, maybe they're going to think you're trying to find a defense. If you just say you're fired, it's a lot easier. You don't have to give them a reason. If you do have a term where you say you will be hired for 1 year, you have to at least abide by that term. And if you do have a term, you want to say that you can be fired for a cause and identify what cause is going to be. Embezzlement, not showing up to the job, things along those lines, things that would constitute cause and a reason for you to fire. Those are only a few of the things. The other thing that I would also stress with employee and employer contracts is have one. So many times I get calls from my clients who will say, this employee did this wrong, or this employee wasn't doing this. I said, okay, well, let me see the contract. And they go, well, we don't have one, or they didn't sign it. I had I know of a situation where we had somebody who was a professional who went from one professional business to another. Now, there was an argument whether or not he was violating the non-compete. And they said, well, you can't work within 5 miles of our office. And if you looked at Google Maps, it was 4.9. And if you looked at Yahoo Maps, I think it was 5.1. So other than that dispute. But what happened and why this failed so quickly is they said, we need a copy of the signed employment agreement. The employer didn't have it. So they couldn't enforce their non-compete. So that is why these agreements are so important. Not just that you get them signed, but you keep signing copies.
So another issue that's important, and we see this a lot of times in litigation, and I know Rob deals with it he's dealing with the transactional issues, is bylaw compliance, not just bylaws, but operating agreement compliance, anything that governs your business and the relationship between the owners and the business is critical. We've litigated numerous shareholder oppression issues, or even member oppression issues, for someone who has a small percentage of the business. The majority of people feel, well, we're going to get any vote that we want. If we're 75% of the ownership of this business, it doesn't matter what happens to the other one. Well, that's not exactly true, because many bylaws and their own state governments do give certain rights to every member or any shareholder. And I can't tell you the number of times that there are bylaw, operating agreements, and other internal agreements amongst the owners for how the business is to operate, and there's non-compliance. That can cause you problems internally, and also cause problems externally with the government.
Yes. The other thing with regards, bylaws and operating agreements. So many businesses also do not have them. The bylaws and the operating agreements kind of act as the Bible of your corporation. We have a client recently who passed away. And they had several different businesses that they were either a member or shareholder. Why were those operating agreements and bylaws so important? We now know how to value his interest. You have the opportunity to determine how to value that interest, and whether or not you're going to use the fair market value or the book value. And that's very important from a tax perspective. It's also very important from a perspective of how much money am I going to get, or how much money is my family going to get if I were to pass away? What's going to happen when I pass away? What happens to the business? What happens to my interest? Who's going to take it over? It's important to the person who died. It's also important to the people who continue on that business. Because if I give that person the right to pass along their shares to whomever they want, I could now have to deal with their children. I could have to deal with their spouse or their best friend. So you want to list out who you have: permitted transferees, non-permitted transferees. Are you allowed to simply transfer your interest? Am I allowed to sell my interest to anybody I want anytime? Or do I have to, or is there a right of first refusal? So these operating agreements are very, very important, not just into the operations about what can happen after the business as well, and how people can leave from a business. Another thing we'll talk about with regards to employees are employee manuals. Employee manuals, and you'll read this in every employee manual you'll see, and I'll say it right now, it is not a contract. It is just a recommendation. It's a way for your employees to know kind of how the business operates. What are the holidays for the business? What days do they have off? What time do they have to be there? Are they allowed to smoke on the premises? Are they allowed to eat anywhere they want? Little things like that make it a lot easier for your employees to function, because they have that rule book. It makes it a lot easier for the employer because you have that rule book that you can enforce or to show. It's also important with regards to vacation time and vacation pay. Maryland requires you to pay vacation time on somebody leaving unless you state otherwise. And that's where you can state it, the employee manual. And it's a way to use it as to with regards to notice, to say, if you give 2 weeks notice, you'll get your vacation time pay. And that's a way to benefit both you and them, because they're getting what they want and you're getting at least your time notice and other requirements that you might have.
So along with those topics, the next advice we give to everybody is record keeping. I cannot tell you the number of times I've gotten involved with disputes for businesses, and all of a sudden we're looking for X, Y, and Z. If they told me they had, but we can't find it. We dealt with even this, it is true even in the estate matter. We've dealt with estate matters where someone has passed away. We need to find out all the operating agreements and bylaws of all of the businesses that they own. We go back to the businesses and their family members. No one's got a copy of the signed operating agreements. And this is true not just for the business's own internal documentation, such as the bylaws, such as the operating agreement, but also, remember we talked about earlier with the releases? If you have all these releases from your past employees, from other businesses, from the dispute, but then when it comes time to enforce that release because they're suing you and you can't put your finger on the release, you're going to have a problem. And so I can't tell you the number of times. One of the business grouping that we give with a lot of sports and outdoor recreation. This area along the river has a lot of businesses that deal with outdoor recreation. One of our clients, who's an outdoor recreation business, make sure before anybody gets on the river for canoeing or kayaking, they make sure everybody had a good release. Now, we weren't the original party that drafted the release, but I know they were having it. So as part of my review of what they were doing and kind of shape them up for future references, said, okay, where are the copies of all your releases? Are there somewhere in a warehouse? The timeout. What do you mean somewhere in the warehouse? Well, we think we have it somewhere. Well, this person went back and couldn't find, except for the current season of releases, any of their releases. Major problem, because if one of those later people, the statute of limitations of those most torts in Maryland, although there's some, it's not 3 years. Someone from 2 years ago could easily come back and sue. You don't have the release from that party. It's as good as useless. Record keeping is critical for businesses for all sorts of legal reasons.
The other thing that we talked about contracts, we talked about employee contracts, we talked got employee manuals. The thing about all of those is that they are all in writing. Put everything in writing. That is one of the most important things to do. I've had so many times, I had a litigated case where somebody said, well, they kept promising me this, and they kept telling me they were going to do this, and I have all these emails. The emails were clear as mud, I'll be honest with you. And the promises you thought were there were not there. And because we didn't have a written agreement, they lost out on all this time and effort and money they put into a business that they own none of the business. When you do have a written agreement, one thing that most attorneys will put into that agreement is that this is the entire agreement. Anything said beforehand, afterhand is not part of this agreement. The only way to change this agreement is in writing by the parties with a signature. So there have been plenty of times where, my client has come to me and said, oh, well, they told me they're going to do this, and this is what we're going to do. And I said, okay, well, that's not what the agreement says. I've gone in, I've changed the agreement to say that. We send it all to their counsel, it comes back, call that red line back out at me, going, no, we're not doing that. And I said to my client, okay, look, I put what you told me in there, but they're not willing to do it. And I had this on a deal where we went back and forth numerous times. My client would always call me and say, okay, we just met with them. We talked with them again tonight. They have now agreed to that. I would do it. I would send it out. It would come back to me, and they would kick it out of it. So once again, that's why they know it, is that if it's not in writing, part of that agreement, it's not happening. So make sure that if it's supposed to happen, it's in that agreement.
Well, in addition to which, along those lines, a lot of times parties make and businesses make agreements to agree. See them all the time. Just a notice of intent, what the parties are going to be doing. We want a contract with you, and these are going to be the basic terms. Now, in Maryland, believe it or not, these agreements to agree, and this is recent precedent for the last 5 years, many of these agreements to agree are enforceable. If your agreement to agree has the basic tenets of what you want in your contract, that could be deemed a contract by itself. Now, most companies go back in those transactions and later have a secondary, more detailed contract. That happens all the time. Sometimes it's forgotten, sometimes it's not. But what happens to that initial agreement to agree? We advise all of our clients to put language in that more detailed contract. That any prior contracts or prior agreements on this issue is null and void, and what's in this contract is the parties' agreement. Well, how does that come into fact? Ted and I are actually litigating a matter where there was an agreement to agree that might have been enforceable and has numerous obligations on behalf of our client. Well, the later agreement, that's much more detailed, specifically has that clause that says we are not going, this is the final, any prior agreements proposals don't count. Well, those obligations were not in more detailed one. So they're not going to be able to claim in any litigation that those prior obligations were part of the agreement, because the final agreement that said this is all of our agreement didn't happen. Now, the final thing we want to say, and I know we're getting close to the 1:30 mark, is what I always talk about is the law and order. Most people here have probably seen Law and Order in TV shows, and Glenn Ives kind of smiling because he's the former state's attorney from Prince George's County, and you hear cops say this all the time as part of the Miranda rights. Anything you say can and will be used against you in the court of law. Now, everybody thinks, oh, well, that's just for the criminal context. It's not. It's for businesses in the civil context too. Why is that Miranda ruling there for criminal? Well, because there's something within the court, this is in criminal law and civil law, that anything that you say as you're a party in a lawsuit, you can't use it as proof, right? If I say, well, in the middle of a courtroom, well, I told him that, so that should be ruled by the court. Of course, not going to accept that. However, anything that you say, your party opponent can use as evidence. This is true in the criminal context, and it's true in the civil. So if you're negotiating a business deal and you say something to someone about the context, or even an admission with regard to the beginning of a dispute that might be in litigation, anything that you say to them, they can be writing down, whether it's an email, they have a printout copy of it, or a statement. They can come into litigation a week later and say, he told me X. That's admissible in the court of law. And I can't tell you the number of times that my clients, either in written emails or in letters or in statements over the phone or in person, have said something that the opponents bring out, they said it. They said, well, they can't say it. No, you can't say it. They can. So I always caution clients, especially at the beginning of any dispute, careful what you say. If you think that you might get to litigation, get an attorney, even if it's an attorney that's not going to be with you in litigation, but outside of that dispute to guide you, because the littlest comment that you think is innocuous could be part of the cause of action. It could be an element in the cause of action that could cause you extreme trouble down the road.
And one final thing we'll talk about real quick is, it's a young group of people here for the most part. But planning an exit strategy for your business, now is the time to do it while you're young, because it can take some time to find somebody who might buy your business. Not only do you have to find them, you have to train them. You also have to ensure they have the money to buy your business. What happens if they buy your business and then they default on the payment? Are they getting a payment from somebody else? Are you going to sell it financing? These are all things that I tell my clients, it can take anywhere between 5 to 10 years to figure out how to sell your business and to who. Now, sometimes you can find somebody quickly and it will process, or I've had clients who have sold their businesses to large corporations, and therefore, you're dealing with a large corporation. But if you're looking to do it in-house and have somebody from in-house take over, that's where you're going to need more time to structure that business. You also want to structure it in the sense of, once again, what happens if I pass away before any of this takes place? Do you have your will in place? Do you have a trust in place? Do you have a power of attorney in place? If God forbid, you can't make financial decisions, who's going to step in on your behalf? Make sure you're prepared to do all of those things from the outside as well.
So I know we have a little bit of time for questions. If anybody has any questions about things we talked about, we'll also be here for a little while longer. In addition to which, what we kind of talked about, you saw our notes, we thought there'd be a projection for people to kind of a PowerPoint presentation, but I know it turns out the restaurant's closed, we don't really have the technology. We're happy to email anybody kind of PowerPoint presentation, the kind of nuts and bolts of the things that we talked about, but we're available to answer questions here for a couple of minutes, and we'll stick around. Our business cards are on the table, so if anybody has any questions. Anybody at the outset have any questions that we'll be able to answer any of the topics? Well, our emails are there if you have any kind of follow-up questions. We're here to answer any questions if you have, some follow-ups afterwards. But thanks all for coming, and glad to see so much support for the Chamber of Commerce. Oh, also, I know a lot of businesses are concerned about kind of political issues. I know here today, there are 2 candidates running for office. Glenn Ivey, who I mentioned before, he's actually running for Congress. And his district comes out of and actually Joe Vogel, who's actually the running for District 17 delegate, which is based out here in Rockville. So, their stances that might reference or help businesses. I'm sure they'll be sticking around a little bit here.
Thank you.